Einen schönen guten Nachmittag aus der Hessischen Landesvertretung hier in Brüssel. Zu diesem Livestream am heutigen Tage ist es ein Expertengespräch, um genau zu sein, zur E-Evidence-Verordnung. Die Experten wissen, was es ist. Es geht um elektronische Beweismittel, um es mal so frei zu übersetzen. Untertitel: Wie kann Internetkriminalität...
Subtitle: How can cybercrime be fought effectively? We have 1 hour to talk about this topic today. It seems and sounds quite dry, but it's far from dry, as often with legal matters, actually. Before we start, a few words concerning our housekeeping for the online meetings as we use today. You can ask questions, streamline at LV-Brüssel with a U and E .hessen.de, and on our hotline as well, 0032 472 030181 in English and German, just as the discussion today will be taking place in English and in German as well. Before really getting started, I should like to give the floor to Mrs. Puttrich first of all, the Hessen Minister for European Affairs, for a few welcome words to you. Thank you. Dear Commissioner Reynders, dear Member of Parliament Körner, dear Mrs. Ballon, dear Mr. Franosch, dear Mr. Kafsack, ladies and gentlemen, the audience. Together with my colleague, the Hessen Minister for Justice, Eva Kühne-Hörmann, I should like to welcome you to the expert edition on the e-evidence regulation. I welcome the fact that with the responsible member of the European Commission, Commissioner Reynders, is taking part in today's discussion. At the center of the discussion, we have the cross-border investigations on cybercrime matters. It's a whole range of areas ranging from insults up to child pornography. Especially in these areas, the anonymous internet has led to a dramatic increase in offenses. Against these types of offences, it is important to act quickly and efficiently. This presupposes that pieces of evidence are secured. A draft regulation on electronic evidence in criminal matters, the so-called e-evidence regulation. Objective being create a means, a simplified procedure actually in cases of cybercrime and where evidence can be gathered in cross-border investigations. The difference to the traditional mutual legal assistance procedure is that the investigating state can request information directly from the foreign internet provider. This procedure allows a fast data access. And the discussion within the European Parliament, it has been obvious that concerns need to be taken into account as well. And that's why I'm happy that with the member of the European Parliament, Moritz Körner, one of the shadow rapporteurs, joins the discussion today. Because respect for the rule of law standards is a central concern of the European Union. My federal state of Hessen is particularly concerned about the fight against right-wing extremism, violence and hatred on the internet. With the program Hessen Against Hate, we rely on the strength of society and democracy, Hessen gegen Hetze. A key element of the action program is a reporting system that provides citizens with the points of contact to report incitement and hate comments on the internet. This will enable state investigating authorities to take action against these crimes on the internet. The reporting system should also increase the risk of detection for the perpetrators. The aim is to deter people who are likely to commit crimes from committing them. To this end, it is important that hate mailings are not only deleted, but that they are first secured for the purpose of criminal prosecution. This is the only way to effectively secure criminal prosecution. Extensive preventive measures are also an integral part of the Hessen gegen Hetze program. They are intended to create awareness of the problem and encourage also civil courage. Young people in particular should be taught how to use the internet responsibly. They should be made aware of the impact hate crime has on the victims affected by it. The fight against hate speech is the fight against crime and not a restriction of freedom of expression. What is punishable in the analog world must also be punishable in the digital world. The prerequisite for punishment is that the perpetrators can be identified in the first place. For this purpose, the identity behind an IP address must first be determined. The user data and the criminal content must be secured for evidence purposes. The planned e-evidence regulation should make a contribution to this. Now, I would like to look forward to an exciting discussion together with you. I hope that the discussion will help to underline the importance of the e-evidence regulation and enable its implementation in a timely manner. Thank you very much. Thank you very much, Mrs. Puttrich. And as we have a European topic being talked about, but a legal topic being talked about as well, we have two ministers responsible here. And now Mrs. Kühne-Hörmann, the Hessen Justice Minister, would like to deliver a live statement and welcome you to this event as well. I'm really happy to see that so many people have been able to join us to talk about this very important topic. We've heard already from Mr. Kafsack that cross-border investigations sound quite complicated in the area of cybercrime, but actually it's quite simple. We all use the internet more and more, and investigations in the internet can only be successful when state prosecutors get the ideal tools to do so. And these cross-border investigations are a topic here. In an analogous way, there would be the traditional mutual aid procedures taking months before you get the information you need. And that's why it is important that the regulation e-evidence gets implemented as soon as possible. I'm really grateful, Commissioner, that this initiative has been taken over in 2018 to prepare something in this area, and I'm quite sad that we still do not have the regulation put into practice. I would like to indicate that in the internet all kinds of types of crime are to be found. We heard about hate speech, child pornography, but all other types of crime have become cybercrime as well, and we will find the perpetrators only if we have quick and efficient cross-border solutions. And only with fast solutions will it be able to punish the perpetrators and protect the victims. Otherwise, we will be unable to act. And finally, I would like to say that I'm really grateful for the initiative being taken and decided on a European level, going for decisions by the European Court of Justice as well concerning securing data in the road traffic area. It is really important to make sure that whistleblowers and others are not affected by this. When prosecutors find the right perpetrators, the rule of law can be maintained. And that's why I'm looking forward to a really exciting discussion. And I would love if this discussion of practitioners could lead to a very quick toolbox for practitioners in the fight against cybercrime in order to protect the victims and punish the perpetrators. Thank you very much. Thank you, Mrs. Kühne-Hörmann. You said this has been launched in 2018, indeed. And the question today will be, why did it take so long? Why do we not have an implemented version of it as well? Why are there still discussions? There's a lot to talk about, of course. That's why we want to take up the opportunity, and I switch to English.
So Reynders into play, and he will tell us in a very short statement a little bit about the state of play, but more about the rationale of the Commission, why we need this e-evidence regulation, the new one, and why it is so important. Mr. Reynders, over to you. Mr. Reynders, I'm afraid we don't hear you. We're trying to fix that. I don't know whether you need to unmute yourself.
Do you hear me?
Yes, we can hear you now.
Ah, fine. Okay. No, I was just saying, thank you very much for the invitation. Vielen Dank für Ihre Einladung. And liebe Ministerin Puttrich, liebe Ministerin Kühne-Hörmann, dear Member of Parliament, liebe Herr Körner, Damen und Herren, but I will switch and sort of English. And ladies and gentlemen, just to say that it's a pleasure to explain to you what we are trying to do at the EU level. And due to the digitalization, criminal activities are increasingly shifting from offline to online. This development has even been accelerated due to the COVID-19 pandemic. Cyber criminals have been at the forefront of taking advantage of the crisis induced by the COVID-19. Their activities include actions such as phishing mails, malware, counterfeits, or the increased distribution of and demand for child sexual abuse images. Another serious issue is the growing dimension of hate crime, in particular, hate speech online. Here again, we have to enable investigation authorities to quickly get hold of the digital evidence to identify and prosecute perpetrators. We need to address these new challenges with tools that are specifically adapted to the digital world. Assessing swiftly electronic evidence is key for our practitioners. To achieve this, the Commission put forward, it was recalled, in April 2018, the evidence package, consisting of two instruments, in fact, a regulation on cross-border European production orders, as well as a directive on legal representatives of service providers. This e-evidence package enables authorities to directly order service providers offering services in the Union to swiftly preserve and produce electronic evidence. This is crucial, as the relevant internet services are often the only ones that have the leads for investigators to determine who committed a crime and the evidence that can be relied on in court. Let me also stress that these instruments will not only prosecute cybercrime, but efficiently, it will be more efficient also in the prosecution of all kinds of crimes. We found that electronic evidence are relevant for 8% of cases. It's very important to use it not only for the criminality and the cyber criminality or criminality on internet, but more than that to have an access to evidence in all the different kinds of crimes and more a request from the prosecutor. Accessing digital evidence cannot follow the same logic as physical evidence, such as paper documents. In particular, the location of the data cannot be seen as the determining factor for defining which rules apply. It can change within minutes based on algorithms designed by service providers for economic reasons. The proposals reflect the specificities of the internet and that in most cases, the person whose data is sourced is located in the same state as the requesting authority. Indeed, the proposals are a shift from traditional cooperation between authorities to direct cooperation between an authority and a provider. The regulation provides strong safeguards as it sets out clear conditions for the request depending on the sensitivity of the data and guarantees for remedies and user information related to these requests. But also the directive is of the utmost importance. The directive is the legal instrument that provides the service providers from third countries are compelled in a legally sound way to designate legal representatives in the Union. This is the basis for sending compelling orders from one member state to the other. And I'm happy to hear the European Parliament is close to adopt its position. This will allow to start interinstitutional negotiation in early 2020. The work of prosecutors and law enforcement authorities. Thank you for such an opportunity to say some words about what we try to do at EU level, and thanks for the support of the different authorities in place to help us to reach such a goal.
Thank you, Mr. Reynders, for this short introduction. We'll now start the panel, and we'll now start to debate about the e-evidence package, if I might call it that way, since we do have a regulation and a directive in this whole construct. Ms. Puttrich has already introduced shortly my panelists, so I'll just name them shortly and then afterwards start immediately the debate. That is, on the one side, Moritz Körner, he's shadow rapporteur for the e-evidence directive, the regulation in the European Parliament. The rapporteur is Ms. Sippel from the Social Democratic Party, another German, but today we'll talk with a liberal, namely Mr. Körner. Then we have Franosch from the the Ministry for Justice in Hessen. It's always difficult to switch between those two languages when it comes to titles. And then we have Josephine, and now I'm a little bit struggling. Is it Ballon? Is it Ballon? How do you pronounce your second name? I don't want to do anything wrong. Head of Legal from HateAid Germany. I try to not to switch too many times between first name and second name. This is always the problem in the Brussels bubble, that we use on a German level the second name and everybody else speaks on the first name basis. So I try to use in English the first name basis, but don't get confused when I mix up both. To start, Josephine. That makes it easier for me anyway, since I don't have to pronounce your second name. To bring a little bit flesh to the bone, we have heard about e-evidence, the theory. We've heard Ms. Kühne-Hörmann and Ms. Puttrich mentioning the problem of hate speech, the program Hessen gegen Hetze, that is. And you're a lawyer involved in, I think it was more than 300 cases now relating to hate speech. In what sense, from your experience, do we need this new regulation? Where do you see the main problems at the moment, and how could that help you to make your life actually much easier than it is at the moment?
Yes, so it was already mentioned today, identification of perpetrators is actually the biggest problem we have. We see this in our work every day, and also what we know from the experiences the prosecutors share with us. This is the biggest problem that we have. To speak in numbers, it's almost 2/3 of the cases that have to be abandoned because of the fact that we are not able to identify the perpetrator behind the account, as we are working mostly with social media comments and messages. If we get a new tool which makes it easier to get the cooperation of the platforms, which we are dependent now that they are cooperating with us voluntarily, and they, I think they have shown in the past that they are not willing to do so, and that's why we need some legal instruments making it easier for us to get the data.
The problem is that you're at the moment relying mainly on voluntary cooperation, that is, and then that makes your life much difficult. And that's where this 2/3 of the cases you mentioned comes from that are that are abandoned in the end.
Yes, that's true. So it's not only my life that would be easier. I think it's also the prosecutor's life, since they have to investigate in these cases, and they have to rely on open source software to get somehow some information about the perpetrators and trying to identify them, because the platforms won't cooperate.
And when you talk about this voluntary cooperation problem, that's mainly because the providers are not willing to cooperate, or it does take too long, eats up too much of your time? Where are the main problems in this context?
So I think it's both. Of course, it's not me asking for the data, it's the prosecutors. But from what I know from their work, it's the problem that they either refer to freedom of speech, so that's the reason why they can't give anything and they're not obliged, so they won't do it. And on the other hand, they are referring to the place of data storage, which is Ireland, as the place of the head office in many cases when we are talking about social media platforms. And that's a very big problem, since from what we know, you won't get any data in Ireland either. And that's not making it easier for us. And it's very easy for the platforms to refer to Ireland or even the US in some cases, because of the country of origin principle, which is in place right now. And that makes it possible to just refer to the head office.
Thank you. So let's switch to you, Moritz, then. We've seen there's a very strong case for this e-evidence package. Why does it take the Parliament so long to agree on that? And we've heard there will be a vote soon in the committee. I think it will be next week, if I'm well informed. But still, I mean, the whole thing was proposed 2 years ago, more than 2 years ago.
Yeah, thank you. I'm working on this issue since I got elected to the European Parliament in 2019. So we're working on it for a long time already. Of course, a little bit in excuse of the Parliament, we have to say that there was the Corona pandemic, and first of all, we had to really, slow down the whole of the business. We were able to vote, but it was very difficult to have at first to have these very complicated negotiations online. We're doing this. We are we're coming to an end. There will be a vote on Monday in the LIBE committee. I think why it took so long is because I understand that there is a definite need for this instrument, but on the other side, we also, if we talk about new instruments, we always have to talk about the right balance with fundamental rights too. And of course, this is sometimes a tricky issue to find the majorities in the Parliament to find difficult compromises. I think we worked on them. For me and my group, especially important is that this is actually a pro-European tool that we can investigate in the whole European single market, and we can directly go to service providers. But this needs trust in the member states and in the rule of law system of the member states. And that's why I am fighting very hard for a proposal which it would include a special protection against Article 7 countries, or the countries who are subject to an Article 7 procedure, especially Hungary and Poland right now. We see other problems with them right now, but I also want to have a very solid solution in these cases, because we have to make sure that we can investigate, but that this tool is not used in the wrong way, and we try to strike the balance in doing that.
So now we're getting to the sticky point, the difficult ones. You're jumping into that right fast. I wanted to leave the cozy area anyway, so that's fine by me. But before we really get to Poland and Hungary, and you mentioned it, we have more than this one problem with them at the moment on European Union level. I would like to bring Rainer Franosch in to talk a little bit about the council side. I think it's a little bit difficult for you, because there's on the one side the German government, and then we have the government of Hessen, who has not exactly the same point of view as the Bundesregierung in this, if I'm well informed. But the council was much quicker. I mean, there was already a general approach and agreement in 2018 and early 2019 about the two parts of the package. But in both cases, Germany, well, actually in one case Germany abstained, in the other one it voted against the general approach. What is the problem Germany has with this package, and do you think the problems they have, I hope I don't get too complicated here, do you agree with the problems the German government voiced in this context?
Thank you very much. You already pointed out quite correctly that the practitioners in the state of Hessen and in nearly all other German states have a different point of view than the federal government of Germany on this point, because what we need is a quick and streamlined instrument to get access to data, especially if it comes to US providers. We have big difficulties at the moment, and it was already mentioned that the e-evidence package contains a directive concerning the legal representative for companies offering services in the Union, but being foreign, non-EU companies, they are or should be obliged in the future to hand over data to law enforcement agencies within EU, which is crucial for the prosecution of crimes involving electronic evidence. So the practitioners in the states have the same point of view as the Commission, and we all think that the general approach already has taken into account any thoughts about fundamental rights. During the process in developing the general approach, there was introduced a new regulation on notifying the country in which the service provider has is situated. And this is, to our point of view, enough to comply with any fundamental rights involvements. So what we need as practitioners is a quick access to data in order to identify the perpetrators and move on to other investigative measures, such as house searches, etc.
So what you're saying is basically that the German government then is worrying too much about fundamental rights, human rights, and they should be more relaxed about that.
No, this is not exactly the point. The point is that fundamental rights are very, very important, of course. And what I'm saying is that the general approach reflects that already. So to my mind, it's not necessary to implement more mechanisms of notifications as we already have in the general approach.
So you would have voted for the general approach then. So you don't share the line. Okay, very good. So that's clear, because we see a difference there between the government in Berlin and in Wiesbaden, of course. So Moritz, let's get back to you then, because you brought this fundamental rights question up, and you mentioned Hungary and Poland. Why are you so worried about that? I mean, if I understood Mr. Reynders correctly, the main idea is to make it easier if one country wants to prosecute against people who live on their territory. So it's only via it's rather a proxy question. We're not talking about Hungary doing anything against people who live in Germany or Belgium or wherever. So why is that question so fundamental, so important for you?
First of all, I would say your assessment is not completely right, because of course they could also go against citizens of other countries. So this is not completely excluded in regulation. And I also care about Hungarian and Polish citizens. I'm a member of the European Parliament, so I do not only care about German citizens. So I think we could solve this problem, and I proposed it if we would do an extra verification. So right now, as the discussions in the Parliament are, we have a notification. So we have a quick access to data, so that the service provider has to give the data out unless the enforcing authority, so the authority in the member state where the provider is located, is against that or has some grounds and objecting to that. And and this is not in our proposal. It's not generally that they have to check every question, but I think when it goes to Hungary or Poland, I think we have to make sure of that, because we know that maybe investigative journalists or other might be prosecuted, and I really want to make sure that this is not happening. So in the Parliament, that's also, I think, the main topic we have. We have both sides in the Parliament also. One side arguing, we need as fast as possible. The other side saying we need a protection of fundamental rights. I always was arguing for a nuanced approach and find compromises. Maybe look into, especially into Article 7 countries, maybe also look into the different data categories. I think it makes a difference if we just look into access data or we look really into content data. So we really had very hard discussions on different topics, and I will see if we find a compromise in the end on Monday.
But that means, just to be 100% clear, that if there was a request coming from Hungary, the German authorities would have to look at that and they could deny the request in case whatever data is concerned, or would that only relate to content data, the most sensible data? How do you want to frame, or how do you want to design that?
So the compromise right now is it would be on content data and on the traffic data or metadata, but it's only that they cannot refuse that on no grounds. So the grounds for refusal are clearly defined in this regulation. So it's not arbitrarily or something, but the problem we see here, and we have to be honest about it, it will not be so much questions from Hungary to Germany or something. The main question will go to Ireland, because the main providers are located there. And we fear that we have maybe a notification of Ireland, but there will be so many questions to Ireland that nobody will really look into them. So we have to make sure that there are the right protections in place, especially Hungary and Poland, but I don't want to make it only about Hungary and Poland. We have some other member states, Malta, for example. We saw very catastrophic situation with a journalist who was murdered there, and so we also wanted to put in some more protection for journalists. And you can say you cannot stop the whole thing because of these thoughts, but I think we have to take them seriously, and we have to make sure that they are really in the negotiations and that we find good solutions for them. And in the end, it will also be, of course, a compromise between the European Parliament and the Council in the end. And to be honest, this time it's the European Parliament which is slower than the Council. Normally we wait very long times for the Council, so I'm happy that I think we will find a compromise with the Council also in the end.
That's indeed a fair point. And you answered, by the way, already the question of Christina Wojcik. I just got, so I can put that already to the side and come to you, Commissioner, because what I would like to hear from you is, of course, how would that proposal, the way to deal with that situation Mr. Körner just mentioned, would that actually improve your proposal from your point of view? Do you see the need to introduce something like that, or is that exaggerated? Mr. Reynders, you're still with us?
Yes, I tried just to see it was my micro. It's better with the micro, of course. No, first of all, of course, we will wait the final proposal coming from the Parliament, because you have said that Mr. Körner, it will be a decision in the LIBE committee next week and then in the plenary, but we are knowing the different amendments. Maybe one word before to answer to your question about the rule of law issue and Article 7. We try to have an efficient mechanism. So we try to avoid too much additional elements in the new system without a real efficiency at the end. And so it's very important to not create insignificant administrative burdens. And so if we need to inform another member state that there is a request from one prosecutor to receive information from a provider, of course it's possible to try to think about something. But again, if it's possible to mention also Ireland, if you receive tens of thousands requests for an access to data, to e-evidence in the different providers, it will be difficult for the judicial system in Ireland to give a very prompt answer. So it will be very dangerous to completely overwhelm their judicial system. So that's the first issue. We need to have an efficient mechanism, because we have, for the moment, some mechanism. And if it's not to have a better mechanism, a more efficient mechanism, will be a pity for the future. Of course, the second element...
Mr. Reynders, if I can shortly interrupt here, because I just want to be 100% clear about that, because that would imply that any kind of a far-going notification system that goes farther than the Council at least agreed upon would kind of take the core out of your whole proposal, right?
Yes, but the first element is to have a real trust, and it's the reason why we discuss about the rule of law and the Article 7. We need to have a trust between the different judicial systems. And if there is a trust, we don't be afraid about some requests coming from one prosecutor in one member state to a provider in another member state. And you know that I've said it's very different with digital tools than in the real life offline. But again, if we have a real trust, we don't have such a problem. It's possible to be confident that we will receive correct requests from the different actors to the providers. If we have some doubts about the independence of the justice system, about the correct application of the rule of law in one member state, it's possible to think about a solution. But we need to be very open and to say that we need to find a balanced solution, because if we avoid any possible request concerning, to give an example, countries involved in Article 7, of course it's not fair, because we need to have first a decision of the Council about the risk, about the rule of law. And you know that for the moment we have 2 countries in Article 7 procedures, but without any decision of the Council. So it's quite difficult to say that we have a real problem without a clear position of the Council. And the second problem that I see, we need to avoid to create sort of loopholes or safe havens for criminals who could take advantage of less efficient tools to fight crime in their member states. Because if we don't have the possibility to work with 1 or 2 member states, it's maybe a good place for the criminals to try to organize their business. So it's also a risk. We need to, first of all, to have a common approach. And I want to say that we have the same problem for the moment with the open arrest warrant. We have some discussions between the judicial system about the possibility to apply the open arrest warrant due to a lack of confidence in the independence of some justice system in other member states. And my feeling is that we need first to put into place a mechanism, and then to see if there are some needs for exception. But we need first to have the mechanism. And I'm sure that, again, the mechanism must be based on the full confidence in all the other justice systems. Is that the basis of cooperation in the judicial and certainly in the criminal matter? But if we have some doubts about the full respect of the rule of law in one of another member state, it must be an exception to a general mechanism. And so, again, the reason why I make a remark about the necessity to organize an information process, it will be too difficult to manage that for the judicial systems in the different member states. So we need to have a very simple system in the entire European Union, and then we will start discussion with the Parliament about what is possible to do if we have some concern about the independence of one of another justice system, if we have some concern about the rule of law.
But that would only be a second step then, if I understand that correctly. So then would mean we finish the negotiations about the e-evidence, and afterwards we look whether we're going to have problems and how we deal with that, because we can hope that there will not be too many problems actually, and we shouldn't be too strict in the beginning.
But that will be difficult because I'm sure that the Parliament will ask to solve all those issues together. But no, I mean, we need to first put into place in the regulation and directive a very efficient mechanism for all the member states on the basis of a full trust in the different justice systems. And then at the same moment, it's possible to think about what kind of possible exception if we have a real concern about the rule of law in one member state. But again, we need to take into account the risk of a non-independent justice system, but also the risk to create loopholes for the criminals in one member state where we don't have access to the evidence. So it will be a complex discussion, but I'm afraid about the fact that we try to have a less efficient system between all the member states to give an answer to an exceptional situation about the rule of law in one or two member states. So again, we need to try to see if it's possible to work with a common approach for the entire Europe, with a full trust in the judicial system, and to see what are the safeguards if we have some concerns about the rule of law. But that must be for specific cases and not in general, in the general mechanism that we are putting in place. And that's the risk that we have seen with the amendments coming from the Parliament. If you agree on all, I've said to the Parliament members in different bilateral discussions, I'm not against some additional safeguards, but we need to be sure that at the end, we will have a more efficient mechanism than the actual one. If it's not, it's a nonsense to try to do that. And you know that there are many discussions now to try to have a better access to different kinds of data in the fight against terrorism, but in the fight also about against child abuse, sexual child abuse on internet and so on. So it's a difficult issue, of course, but again, we need to have first a real efficient mechanism into place and to think about in such a mechanism, what are the possible exceptions if we have a real concern about the rule of law.
Josephine, from your practical experience, of course, you're worried mainly about getting access to data as fast as possible, but do you share or do you see or understand the criticism that comes from the European Parliament, and do you think the approach the Parliament has chosen is the right one? The screen is just switched off, so I cannot see you anymore, but I hope you can see me. That's the most important part, of course. Do you think the Parliament is going too far, or do you understand what the Parliament is saying?
Yes, difficult question. Of course, for me as a lawyer and also as a citizen, it's also worrying to see that in the European Union we almost have to feel blackmailed by two countries who are not sticking to the rules and values that were agreed on in the beginning. On the one hand, of course, HateAid is a consultation center for victims of digital violence. And digital violence comes in many forms and ways, and most of our clients are activists. They are activists on a political level. They are also somehow involved in society, relevant questions, you can say, in general. And there are also minority groups, especially we have many women, also LGBTQ persons. And that's a problem I see. In Germany, we have a completely different situation, and I see the struggles that law enforcement has at going after perpetrators on the internet, getting the data. It's really, really difficult. And I also know that the perpetrators themselves know that it's very difficult for law enforcement to go after them. They even communicate about this on the internet, where they're organizing their actions, and they're also communicating this towards our clients, so to the persons affected by this online digital violence. And this is a huge problem. On the other hand, of course, I'm also worried about what happens to activists in Hungary or Poland, because they may get some very serious problems if their government is acting the other way around and is trying to use this regulation against them. So, of course, yeah, I'm also in favor for some solutions that might see some possibilities of notification, for instance, of the Justice Department, or there are also some other solutions discussed around this also in the civil society. And I think there should be a closer look to this problem, but we also have to see that we get something in place that is also working in the end. And I know it's really difficult, and I'm very glad that it's not my job to do so. But I really appreciate the discussion we have about this here right now.
So we're kind of between a rock and a hard place, as you say, yes. Because on the one side we need a system that really works and we get access to data quick within the 10 days, and on the other side we want to have some safeguards against misuse, if that's the right word in this context of the e-evidence idea. Mr. Franosch, what's your point on that? I mean, you made quite clear that from your point of view the notification system the member states agreed upon, and that only relates to the most sensible data, is enough. So you think that's safeguard enough against such problems?
Yes, this is what I think, because out of my practical experiences, more than 90%, I think it's like 93% of all requests for data which is stored abroad and processed by service providers pertain to local national cases. What I'm saying is that the German prosecutor, as the Polish prosecutor, prosecutes German cases, as the Polish prosecutor prosecutes Polish cases. At the very moment, we all have to go across borders to get data we need in domestic investigations. And this is the big problem, because this takes too long.
I'm afraid we...
And I fully agree that system which is grounded on the...
I'm afraid we lost you. I can only hear certain bits of what you're saying. I don't know whether you can just log in again or whether we can solve that any other way. Okay, I cannot hear you anymore. I get back to you later. It's just get to Moritz. Oh no, let's go to Commissioner Reynders again, because Mr. Franosch mentioned the 93 or 94% of cases that are purely on a national level. But then again, the other thing Josephine mentioned is, can't you understand that some people don't really feel at ease when they have to accept a regulation where Germany, for example, helps Poland to investigate a Polish citizen that lives on Polish ground in relation to, let's say, LGBT, well, I hate this abbreviation. You know what I'm talking about, because they're just not in line with the national Polish law. Because generally speaking, that's not a law we like at all on a European level.
No, but I fully understand that, because I will have just now another meeting about the rule of law and the situation, the actual situation in the EU. So it's, first of all, it's true that we are working with the evidence package, first of all, for a huge number of domestic cases, because it's true that with the digital tools, it's needed to receive evidence from a provider located in another country, another member state, just to solve and to try to continue investigation on a local case. Because in fact, you have, if I may, offline criminality, but you need to collect evidence about such a kind of offline criminality. And then you have also online criminality, that is something else, and maybe more with cross-border activities and sometimes some network and some needs to a better cooperation. But first of all, it's true that we have a lot of dossiers just at the domestic level. The second element, in the evidence package, we need to protect, of course, the fundamental rights. We need to be sure that the request is on the basis of a decision of a prosecutor, of a judge, with a real control about what kind of limits in such a request with an access to e-evidence in a real prosecution, a real investigation, and not in general to have an access to personal data. So we have some rules on this. We have the GDPR, but we have a lot of mechanisms to protect them. But then I insist again on the fact that it's not because we have some concern about one or two member states, maybe, to make a long list, that we need to change the regulation for all. So again, we need to think about an efficient mechanism to let the possibility for German prosecutors to ask in Ireland an access to e-evidence without any doubt that it's possible for a German prosecutor to do that to a provider in Ireland, and then to see if they are concerned about the rule of law in one of another country. It's not to block the request for a German judge to have an access to a provider maybe in Poland and in Hungary. It's just to see what are the requests coming from Hungary and Poland to another member state with a problem. And there, again, it's maybe possible to think about an exceptional situation in the package about e-evidence, or to think about what kind of consequence, give an example, of the Article 7 procedure. But I said we have the same discussions about the open arrest warrant, and we will have the same discussion maybe in many other fields. We have found the European Union on some values, but we have found also the European Union on a trust between the different member states, between the judicial systems, and we try to put into place instruments on such a basis, a real trust between the different justice systems. On such a basis, if we have a doubt about one specific situation, it may be possible to take an exceptional decision about the different requests coming from member states where we are concerned about different kind of rule of law issues. Because again, we want to avoid loophole for criminals. So it must be possible. If you have a problem in one member state, it must be possible for the 26 others to send requests to providers located in such a member state. There is no problem to do that. The only one issue is it possible to block some requests coming from this member state where we have a problem of the rule of law. And on this, it's not easy, but I'm fully aware that we need to think about a solution, but not to apply the solution for all. For all, we need an efficient mechanism, and that's the difficulty. So we need to have a balanced approach to have a real efficient mechanism protecting the fundamental rights of all the citizens by giving a more efficient instrument for the law enforcement authorities and certainly for the prosecutors. And I've had many contacts with many prosecutors about that. And then we need to see if in the European Union we have a real concern about one or two or three member states. There we need to take an exceptional measure. But normally, to be frank, is the Article 7. At the end, if in the Article 7 there is a decision of the Council to say that we have a real risk of breach of the rule of law in one member state, to my mind, it must be logical to say, why not to apply the same vision for different kind of instruments and to block maybe the use of different kind of instruments in such a member state. But I know that for the moment, we have no issue in the Article 7 procedure. So again, we will start the trilogue with, in our mind, two elements. An efficient mechanism applying for all the member states with a full trust in the judicial systems. And then a reflection about what kind of exception for the request coming from one member state where we have some concerns about the rule of law. That's the main discussion. But I'm afraid that in some amendments coming from the Parliament, due to rule of law problems in one or two member states, we change the system, or we want to change the system for all. And that is not fair. We need to continue to have a real good functioning of the judicial cooperation with a full trust between all the member states, except maybe with an exceptional situation in one or two. And that's the main issue, because, again, a request coming from Germany to Poland is not a problem if we are looking to the actual situation. We are more thinking, and I'm sure that that's the reflection of the Parliament. In the Parliament, there are more reflection about what kind of agreement for the request coming from Hungary and Poland, to be very concrete.
Moritz,
why not?
Of course,
a discussion. Yeah. But again, sorry, because I will need to go to a real discussion on the rule of law now in another context. But it was a pleasure to explain what we try to do. But of course, it will be a huge discussion in the trilogue. I'm sure that we'll have some different meetings in the trilogue with the co-legislator to find a solution.
I'm sure about that. Thank you very much, Mr. Reynders, for joining us today, and all the best for what's coming up to you.
Thank you.
So that leaves us with 5 minutes. And unfortunately, a question I couldn't pose from Iris Day to the Commissioner. I wasn't aware, I have to say, that he had to leave that soon, but we'll hand that over later on. Moritz, I still want to give you the possibility to react shortly to what Mr. Reynders just said, and then ask the additional question whether it makes, from your point of view, sense to make a difference between the purely national cases and the 7, 8, 6%, how many there are that are trans-border, cross-border cases.
Yeah, absolutely. I know that there is it's absolutely right. The main cases are purely national. That's also, I took that into account with my amendments, so the Commissioner also knows my position. The problem right now is we don't have a position of the Parliament yet. I was always arguing for putting in extra fundamental rights safeguards by not slowing down the whole procedure, as the Commissioner rightly said. So I was fighting for an Article 7 procedure. I was fighting for an additional, or I am fighting for an additional protection for journalists. And I actually fought even for saying that national cases should be treated not in the same way as cross-border or purely cross-border cases. But this actually is pretty sure that will not have a majority in the European Parliament. So I would say in general, I would say the position of the Parliament will be more safeguards. I feel on Monday will be more safeguards than the Council or the Commission position. But I also argued for example, for a common exchange platform. So we did not only put in new safeguards, but I also worked on putting in the need for a common exchange platform, because we want to make sure that the judicial system and service providers can communicate in a fast way, in a secure way. So we also had discussions like this in the Parliament. And we will see what will be the position of the Parliament in the end on Monday. I can say for my group, very important is special protection for journalists and special protection against wrongdoings of maybe countries who are under Article 7 procedure. This is not about slowing down the whole procedure. The Rapporteur proposed to even have a notification of affected countries. It looks like as that will not be in the final compromises, but I won't say we work really on making sure that there is fundamental rights protection, but to have a functioning instrument, and we will see what will be in the final compromise of the Parliament.
And then, of course, we have the trilogue afterwards, and maybe the one or two things will be remedied then, whatever remedied means in this context. I just want to ask one last question, and I'll ask that to Rainer. He's back online as far as I'm informed, and that's the question of Klaus Langefeld. I post that in German because I have it in German here, and it would be bizarre to translate it.
From the point of view of the service provider, you have to wait the safety of data and the transfer of data to the law enforcement. You can also answer in German.
Well, I stick to English. I don't think that the service providers should be in a position that they have to evaluate whether a request is lawful or not. They simply have to serve the requests, as we have the situation in all the member states. If they receive a request from an authority, they have to serve it. And the remedies and the safeguards which are in the proposal are basically enough, and this is to secure the rights of the service providers, for example, the comity clause and other things which have been tackled. But I think that it's not the task for the service provider to evaluate the legality of a request by a law enforcement authority.
Okay, so we've made that clear. I would now like to hand over to Ms. Kühne-Hörmann again, who listened in the whole debate we had, and to give her the chance. Oh, she's gone apparently, so we have another technical problem. I assume, I hope she was not too bored and left the debate. I cannot imagine that. So unfortunately, we will not be able to listen to Ms. Kühne-Hörmann again, which leaves it to me to close the debate. I think we've learned about why it takes the Parliament so long, and we'll hope that we'll have an agreement within the next 6 months during the presidency of Portugal. But we've seen the two sides are so far apart that this might be a tricky thing to reach. But we'll come back to that later, at a later stage, that is. What I need to mention now is that there's another event, the next event, that's Romania has voted, Rumänien hat gewählt, that's on the 8th of December at 13 hours. And to let you know that in case you want to re-watch this debate, you want somebody else, to invite somebody else to watch it, you can do that via YouTube. The slides will be available there. And thank you all for listening, and I wish you a nice rest of the evening, the afternoon. We're not there yet, although it's already getting dark in Brussels. Thanks a lot and have a good day.